Former Deputy Attorney General Alfred Tuah has welcomed the lawsuit challenging President Mahama's decision to forward a petition to the Council of State for consideration. The president initiated the move on earlier this week, but MP for Old Tafo, Vincent Ekosifa, has petitioned the Supreme Court to nullify the decision. Here are excerpts of the suit that I'm going to be rolling on your screen for you shortly. Right, and on your screen, petition to remove CJ, and the nature of reliefs that he's seeking as follows. A declaration that upon a true and proper interpretation of Articles 146, Clause 1, Clause 2, 46, and Clause 7, and Article 23, 57, Clause 3, and 296 of the Constitution, the President is mandated to notify the Chief Justice about a petition for the removal of the Chief Justice and obtain his or her comments and responses to the content of such petition before referring the petition to the Council of State or commencing the consultation. It continues to say that a declaration that upon a true and proper interpretation of Articles 146, Clause 1, 2, 46, 7, 23, and 297 of the 296 of 19 Constitution, if allowed by the President to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process by the Council of State, will amount to a constitution of violation or will constitute a violation of Article 146, Clause 6, as well as the constitutional protection of the security of tenure of the Chief Justice, who is a Justice of the Superior Court of Judicature stipulated in Article 146, Clause 1 of the Constitution. Now, the third one will be a declaration that upon a true and proper interpretation of the above articles that I'd already mentioned, a failure by the President to notify the Chief Justice and obtain his or her comments and responses to a petition for the removal of the Chief Justice before triggering the consultation process with the Council of State amounts to an unjustified interference with the independence of the judiciary enshrined in Article 127, Clause 1 and 2 of the Constitution. Then it continues that it's seeking a declaration that the failure by the President to notify the Chief Justice and obtain her comments and responses to a petition for the removal of the Chief Justice before triggering the process for her removal constitutes a violation of the fundamental right of a fair hearing contained in Article 23 and 296 and renders the consultation process for the removal of the Chief Justice initiated by the President null, void, and of no effect. Well, and any others as the Honorable Court may seem to meet. And here are the reliefs that Vincent Ekosifa is seeking the Supreme Court for. Meanwhile, in a newly published write-up, a private legal practitioner, Thaddeus dismissed the MP's lawsuit as, quote, much ado about nothing, end quote. Here are excerpts of the questions he raised regarding the suit as well, and I'll be rolling them on your screen. It says that petition to remove CJ, comment by Thaddeus says that if the Constitution explicitly states that where the petition is for the removal of the Chief Justice, the President shall act in consultation with the Council of State, it is unconstitutional for the President to refer the petitions to, is it unconstitutional for the President to refer the petitions to the Council of States? The question he's asking. It also continues to ask, should the President unilaterally decide on the petitions without engaging the Council of States as mandated? That's another question he's asking. He says that, does referring the petitions to the Council of State amount to a prima facie determination without giving the Chief Justice a hearing? Does his referral prevent the Chief Justice from later providing her comments on the petitions? So these are the concerns that Thaddeus has been raising on the suit challenging the referral of the petition to the Council of State. But let's also engage former Deputy Attorney General, Mr. Alfred Tuah. Well, you have heard and you have seen the responses by Thaddeus What's your reaction to this? I earlier in the afternoon engaged with you on your position as to whether the suit really has merit, and you were giving us some education. But what's your reaction to Tadiosaurus's questions that he's raising?
I just heard the questions that you read out. I do not know whether Tadiosaurus provided answers. And I do not intend providing any answers because as a senior member of the bar, I do not have to do anything that will be prejudicial to the substantive matter. But questions can be raised about the suit. And so that's my response to the questions raised by Councillor Tadiosaurus.
So let's just have some education as well on the Article 146 and the process, particularly that allows the president, when a person petitions, and what the president should do. If you look at the provision 146 in its entirety, and so far what the president has done, the steps he has taken, does it look like any violation at all on the face of it at all?
If you take a look at Article 146 of the Constitution, it deals with removal of superior court judges. And you have two categories of superior court judges, if I may put it that way. You have the superior court judge as a superior court judge, and the other side, you have a superior court judge who is the chief justice. When it comes to the removal of the chief justice, you must first and foremost know that she is a superior court judge. And so all the provisions relating to the removal of superior court judges apply to her. And that's the very reason why, in a particular matter, you've heard about Prima facie determination. If you read the original text of the Constitution, you don't find that provision when it comes to the removal of the Chief Justice. But it took a citizen of the land to take the matter to the Supreme Court somewhere in 2005 for the court to read into the provisions in 146 that the Chief Justice, being a judge for that matter, is also entitled to have that provision relating to prima facie determination. And in the JQ case, the Supreme Court made it clear that the president will have to make the prima facie determination in consultation with the Council of State. I think when the president received this petition, he decided to forward it. I'm not part of the presidency to the Council of State. Now, the question that's coming up is whether a prima facie determination can be made without notifying the person whose conduct in court is being questioned in the petition. So that's the essence of this particular suit that we all read. But looking at the Constitution, you may want to say that there's nowhere written in the Constitution that the subject of the investigation should be notified. But what has been the practice? I mean, the current administration has been in office before. There are other administrations that have been in office. And I think we have to leave the Supreme Court to determine whether, upon a careful reading of Article 146 and other relevant provisions, especially Article 23, 296, and 7 of the Constitution, before the president can consult the Council of State to make that prima facie determination, the PJ ought to be notified.
Okay. Again, some education here. Until a prima facie is determined, what then will the Supreme Court judge or the judge, what would he or she be responding to? Just the petition?
Two things. Notifying her that 3 petitions have been filed against you and that is being submitted to the Council of State for a determination of whether there's a prima facie case. And secondly, that from the principal point of view, also asking her to provide her comments relative to the petition that has been filed against her. And that's the crux of the case of the plaintiff that the Supreme Court is going to determine.
Okay. So, for example, if he or she responds to the petition and agrees to whatever allegations that the Constitution actually provides that these petitioners have raised, then there will be no need for the prima facie, or it is when he or she is saying otherwise that we can proceed to the next stage?
In terms of the prima facie, even if the person is notified and she admits the Constitution has not made a provision that the process must be truncated. So we have to set up a committee for the committee, five-member committee, to go into the petition. And so it's not about whether the person is admitting or denying. The process must be triggered from the start up to the end of that particular proceeding.
Please hang it there for me. I'd like to engage a private legal practitioner, Martin Pebu. I thank you for joining us this afternoon. I am certain that you may have seen the reliefs that Ekwasefa is seeking from the Supreme Court. And again, you may have seen the reaction from Thaddeus Story. He's been raising some questions. But on the face of it, has the president in any way erred, especially according to 146 or any other provision at all in the Constitution? Do I have? Oh, forgive me. I'll try and see if I can reconnect to Martin Pebu, but I'll go back to Mr. Tiayebo again and find out. Well, maybe this gentleman, as I spoke to you this afternoon, you mentioned that we don't know the information that is available to him. Otherwise, then my question will be the entire process with the learning that should be done in camera. At what stage then do we as a people or the public or this gentleman who is a citizen, which is why he's seeking this relief in court, would he know that the Chief Justice has been notified or not?
No, in terms of the camera hearing, in-camera hearing, it is about the content of the petition and the hearing of that petition.
Okay.
That's what's covered. So the content and then the hearing. In any event, I think it's now settled legally that even if the petition is made available to the public, it does not vitiate the proceedings relative to the removal of a person from office as a judge.
But at the moment, would it mean that until the president is seeking a response or a reaction from the Chief Justice, he or she cannot elect himself or herself to want to react to it in any way at all?
If the relief as claimed by the plaintiff are sustained by the Supreme Court, then that is the meaning. It means that the current president and future presidents will have to abide by such a decision.
Okay. Please, again, hang in there for me. I'd like to engage Mr. Martin Pebu. Thank you for reconnecting with us. Has the president in any way, procedurally, erred in any way, looking at it with the face of 146 or any other provision in the Constitution? Mr. Pebu, kindly unmute.
Yes. All right. So I said I don't see any breach of the law by the president. Not at all. You see, there are some parts of the process that we are mixing up. Let's understand the process is in two stages. The first part is that when the president receives it, that's the petition for the removal. The president, in consultation with the Council of State, must make a prima facie determination. It just simply means the president should look at it and see if there is any basis for the tribunal to be set up. So contrary to what I heard Senior Tiayebo submit, the setting up of the 5-member tribunal is not automatic. The prima facie determination must first be made. Now, in order to make that prima facie determination, you don't always need the response of the Chief Justice, or if it's any other justice of the Supreme Court or Superior Court. But in this case, I'll limit to the Chief Justice. So let me explain. Assuming that, please, what's your name again?
MFR.
Hello?
Mr. Pebu, my name is MFR.
MFR. Assuming you are Chief Justice, so Chief Justice MFR, and then let's say that Kaloni is President of Ghana. So Mr. Tiayebo makes a petition against MFR, the Chief Justice. Kaloni is President. He receives it. Now, MFA has not signed the petition. So you wrote your name, but you didn't sign. So Kaloni looks at it and thinks that this thing that is not signed, I want to dismiss it, because once MFA has not signed, how will we know that MFA is truly coming from this thing? Sorry, Tuayebua. It's Tuayebua who is making the claim. So based on this, you don't need a response of MFA as Chief Justice. Mr. Tuayebua's petition can be dismissed by the president consulting the Council of State. It's not necessary. Number two, it's also possible that even MFA would sign but doesn't write her name. In that case, it's even worse. We don't even know the name of the person making the petition, right? In that case, the president, in consultation with the Council of State, can dismiss it without asking the Chief Justice to answer. So you see that many other mistakes can be made. Assuming the president receives a petition, which is just full of insults, invectives, vitriol, doesn't say much, but just keeps insulting, rambling over, doesn't make sense, too many typographical errors, is incoherent. How are you going to give that to the MFA as Chief Justice to respond? No. So the president will consult the Council of State and say, listen, I've dismissed it. So I think that we shouldn't run ahead of ourselves. What we should watch is that what the president cannot generally do is that if they find there is some merit in the petition, they cannot say Chief Justice Tokodo should go before the tribunal, the 5-member panel. That's the stage 2, if they've not heard from her. So that is the only one that would be a breach. But as for receiving the petition, the president must peruse it. If he has any concerns that he thinks makes the petition defective, he will consult the Council of State. I think this petition is defective in this respect. I'm going to dismiss it. What do you think? If they agree, it's dismissed. You don't need MFA as Chief Justice to respond. Please.
And so this performance of the president, is it discretionary, or there's a law that allows him to say, well, on the face of it, I just want to forward it to the Council of State so that they help me determine a prima facie case? Or I think that even before the determination, I want to engage the Chief Justice and say, well, there are 3 petitions against you. What do you say? Is it discretionary, or the interpretation of the law amounts to this?
It's the interpretation of the law.
Okay.
It's the interpretation of the law, because prima facie means that the accuser has said something. So you can look at what the accuser alone has said, and you can dismiss it outright without asking the respondent, in this case, the Chief Justice, to respond. So even if we understand the meaning of it, and Samselade Ayenini has written a beautiful article on it. You Google, you find it online. Beautiful, because he did the Shraj case, Loretta Lamte. You know, at that time, other people who sent in their petitions, they wrote and didn't write well. So Chief Justice Georgina would dismiss those petitions without even asking the Shraj boss to respond, because those other petitions were not good. Okay. So she threw them out. It is the one Samson Ladi Ayenini, the host of Newsfile and lawyer, wrote that was taken in and eventually led to that. There are many other examples that we could give. Even the word, let's all understand, prima facie, it means that you, the one bringing in the petition, if you don't write it well enough and it's defective, the president can consult the Council of State and dismiss it without asking Chief Justice to. So we are running ahead of ourselves when nobody has seen the petition. So let the president consult.
When the Chief Justice responds or is engaged on this, will it also be done privately? Will the public see it? What does it mean when they say the process is done in camera? Good.
So this is what is going to happen. When the president finishes consulting the Council of State and he thinks he will dismiss it, he will give a ruling and it will be published. Remember, on the 3rd of January, when Ekufuado did the one, you know, Professor Kwekua Asare, properly called Azar, he sent a petition that Gertrude Tokonu, Chief Justice, be removed. When Ekufuado finished the process, he published his ruling. So it's going to come out. So it's not going to be secretive. And then let's also add, maybe to obviate such lawsuits. That's why in the Frank Ejechu case, the Supreme Court said that there should be rules, proper rules should be drawn out, fleshed out, so that it can avoid some of these things. But trust me, the president and the Council of State can look at this thing first to determine if it's proper before they will send it to Chief Justice Tokonu. If they think it's not proper, they can dismiss it and not ask Tokonu to respond. Please.
Okay.
Yes.
Please stay with me. I'll come back to you. And when I come to you, I'll be finding out from you the constitution of the tribunal, as it will be by the Council of State in consultation with the president again, whether there is any conflict of interest in there. So please stay with me. But on phone, I'm joined by Sam Okujeto, former chairman for the Council of State. And I'd like to engage you on this because of your role and your performance in the Council of State over the years. This application, this petition, and a citizen, for that matter, a member of parliament, going to the Supreme Court to seek this particular relief, is the whole process coming to you as a surprise? And if not, why?
Well, you're asking an interesting question. The petition has been submitted to the former president on that same issue. It was referred to the Council of State. The council decided that there was no prima facie case, that indeed the person who wrote the petition doesn't seem to understand the whole process of the judicial administration and the powers which are given to the Chief Justice. Unfortunately, that person publicized the petition that he has sent, which of course we thought was improper. You see, when a petition is sent to the president and you go and you give it publicity, you give a whole hour, then tomorrow somebody will come and start speculating as to why did the president not do this, why did the council not do that. It is not meant for public consumption. So we need to understand that clearly, because you taint the high office of a Chief Justice, a very extremely important position in the legal hierarchy. The law says that the president should send a petition to the Council of State. It is responsible of the Council of State to consider that petition. If it feels that no prima facie case is made, the subject closes there.
Okay.
It is only when the Council of State has found that there is prima facie case that the process continues for the appointment of a tribunal to do the vetting.
At this stage, would the Chief Justice would have been notified, or it will be after the determination of the prima facie case? And at this point, is it discretionary?
The law didn't say that the Chief Justice should be notified. It didn't say that. But there is nothing preventing the Council of State from sending it to the Chief Justice for a reaction, because that might enable them even more authentically to say that there is no prima facie case.
What does this mean?
Because allegations are made. Sometimes you find out that those who made allegations don't even have any facts to substantiate it.
Okay.
Sometimes it's just speculation that they do. Or sometimes because there is a grievance they have against the Chief Justice, because something has happened, they don't understand it, they will not even go and inquire about it, and then they go write a petition.
What does this mean to the judicial landscape in this country? What does this mean if it moves to the next stage? If it moves to the second stage, where a tribunal is set up, the setup of the tribunal, where if a prima facie case is determined, what does this mean?
If the prima facie case is determined by the Council of State, it is then that they will forward it for the composition of a tribunal.
Yes, please.
That is the way it is. But I'm saying that before then, those things are not meant to be an issue for publicity and for conspiracy. Because when you do that, you taint the whole of the judiciary.
Currently, has the president breached any of the stages at all?
Unless somebody from the presidency went and publicized it, then that becomes a problem.
Okay.
That is my view.
So far, concerns have been raised that the Chief Justice has not been notified. And so there's a citizen of this country called Vincent Eko Asefa, who is a member of parliament for Tafo in the Ashanti region, headed to court seeking certain declarations, Tafo, seeking certain declarations that because, and the crux of his relief that he's seeking is that the Chief Justice at the point of Prima facie case that the president is consulting the current Council of State members for, the Chief Justice has not been notified, and so it will amount to a violation of the fundamental right or the fair hearing and a few other things that he mentioned. Has the president...
How did he come to know the point that I'm raising? I'm saying that you, the media, sometimes you are so quick in jumping at issues that things that maybe you shouldn't talk about, you want to talk about. That is the whole issue that I'm talking about. I'm just saying that when the previous petition was sent, the person himself went and publicized it. And in the ruling of the Council of State, we said that what they had done was improper. That it was improper for him to go and publicize. It's like I'm sitting here, then someone come and I said, this person has done something. I suspect that it's a thief. Well, my suspicion of the thief does not make the person a thief, does it? No, it does not. So unless a case is made against the person, and so, well, maybe you can wait for the Supreme Court to make its ruling because it's the first time of this nature that somebody is challenging them. But I am of the view that you, the media, are sometimes too quick in trying to publicize everything without knowing. If the Chief Justice has not been notified, you, the media, has a way to know. Why don't you ask her?
Well, it's a citizen that is headed to court, and these are his concerns. It does not matter
which of a citizen. What I'm saying is that we are taking this freedom of an individual to do certain things. We are overstepping it.
Okay.
We are overstepping it, and it is not in the image of the country.
Okay.
Because what we are doing now, that publicity that you have started would have gone to the media abroad. Then it is an issue that the Chief Justice is being tried. When in fact there may be no iota of facts or truth in the whole substance of the matter. That is what I'm trying to say.
All right, Mrs. Samukujetu, thank you for talking to us this afternoon. But back to Mr. Martin Kwebu. We were on the process of understanding just the procedure as provided in the Constitution, which I'm not too sure what the media has done wrong for now. But on the face of it, it also suggests that if it goes to the second stage, then the Council of State will set up a tribunal. The question of conflict of interest, has it come to your attention?
I see what you mean, but it's the case that, so you mean conflict on the part of the president, right? Yes, but unfortunately, that's how the current architecture works. The Constitution says it's the president's duty. So usually they say when it comes to constitutional provisions like this, the conflict rule, what you are mentioning, cannot override the express words of the Constitution. It's the same thing that applies to the Chief Justice. So MFI, as we speak now, if there is a matter, okay, in court, right, people would seek to, so let's say the J2 matter.
Yes.
When the J2 matter went to court, the Chief Justice had to empanel the court. A J2 raised the objection that, oh, this matter, it concerns the Chief Justice. And not this particular one, the Chief Justice at the time. So it's not good for the Chief Justice to empanel the judges, that's to choose which judges will sit on the matter. The Supreme Court looked at it and said, no, when there is such a duty to be performed, we cannot use conflict of interest as a rule to prevent the constitutional duty being performed. But in principle, I'm with you. What you're talking about, that sometimes maybe a president may be interested in the removal of a Chief Justice who is not seen to be holding the views of the president or his political party. You have a fair point. There's a question, there's something to be said there. That's how come when it comes to the new Constitution, we are advocating that in the new constitution, the one JM has set up a committee to deal with, we should not have the president appointing the chief justice. We should not have the president appointing Supreme Court judges. We should not have the president appointing High Court judges. We should not have the president appointing Court of Appeal judges, right? So we want strict separation of powers. That's in the new constitution we are asking for. So this, your question, provides further impetus for the constitutional review that most Ghanaians are clamoring for.
Right. Thank you so much, Mr. Martin Pebu. And I'll go to Mr. Tiayebwa for your final reactions. You have heard Mr. Samukujeto. You've also heard Mr. Martin Pebu. But finally, this citizen who's headed to court, I do not suggest that maybe you preempt what the Supreme Court will be arriving at. But sometimes if you look at the law and because of your background in law, the release that he is seeking, is he likely to get all of them?
All right. Once again, I'm unable to offer an answer to that because it's a pending matter at the Supreme Court.
Right.
I'll leave it now. But what I would say is that if you take the Ajay case that we've been talking about, before that particular case, the impression had been created that if a petition was filed against a chief justice, he was not entitled to that proper facie determination. So when he went to court just like this one, people were a bit skeptical whether he was going to succeed or he was not going to succeed. But the Supreme Court read into the Constitution that will enable the CJ to also have that proper facie determination. So this was it's a similar instance where you don't have it explicitly stated, but someone has gone to court. Let's wait and see what the Supreme Court will do.
Mr. Tiayebwa, once again, thank you for joining us today.